Hello everyone, good morning. My name, oh, you know my name already. You're welcome to today's edition of our Facebook Live series. So I know it's been a long time you saw me here, and I missed you guys. And I welcome you back from your travels. For those who traveled out of their states, the states where they reside, to any other state they registered for the sake of voting. I welcome you back, and I hope it was a success. And I hope nothing happened because we had a lot of gist. People were shot and all that. So I hope you're safe. Today, you already know the topic we are going to be handling, and I want to start for starters. I want to say we already know the meaning of election, so I don't need to go over that. But I would like to also state that even though election is not the right to vote is not enshrined in our constitution as a fundamental right, I believe it ought to because it's the process whereby someone has to choose sorry has to choose his or her future. So that's really important. It's really fundamental to the existence and well-being of every human being. So the reason the age for voting is 18 and above is because of maturity and the fact that if you're a minor, your guardian or your parents have to um, make decisions for you. So for that case, the age for voting has been termed 18 and above. So if you're less than 18, your parents or your guardian would vote, and that's like making the choice for you. But if from 18, you have every right to vote. So let's now go back to the main topic for today. I'm not going to bore you. I'm going to be very brief as possible, so that in no time we're out of here. So today's topic is options open to a dissatisfied candidate. And we know that a candidate is someone who, in an election, a candidate in an election is someone who has contested or is contesting for a post in Nigeria. So now, whoever that is, if you're a candidate, if a candidate is dissatisfied for whatever reason, with the regards to the outcome of the election, the person has the option of a petition. You petition depending on the election you're a candidate or you were a candidate in. You would choose out of the several tribunals where you can lodge your petition. Now, for the FCT where we are, there's what we call Area Council Election Tribunal, and that tribunal oversees, in the exclusion of all other courts and tribunals, oversees all issues of election with regards to chairman, vice chairman, councillor in FCT and nowhere else. So this tribunal has the constitution. What we mean by constitution is the people who are in the tribunal who oversee these things, give judgments and all that. So this tribunal, that's what when we say constitution, that's what it will mean literally. So it consists of this tribunal consists of a chairman who must be a chief magistrate and two other members who must be magistrates from FCT, from any other court, magistrate court in FCT. Then, of course, some legal practitioners who have been who have been called to the bar for not less than 10 years, and of course, who have records of good integrity and all that. So the appeal for where a candidate who has contested in for a position for chairmanship or vice chairmanship or councillor position in FCT, when the person who has gone to this tribunal now is not still satisfied with the judgment of this tribunal, the person can now go forward to what we call Area Council Election Appeal Tribunal. So this one consists of a chairman, of course, and two other members. And this chairman has to be a judge, a chief judge here, and the other two members have to be judges judges of courts in FCT. So now, like I said earlier, depending on the position you have contested for, you are open to different tribunals, to a particular tribunal to go to. So for gubernatorial candidates, election candidates, and presidential election candidates, the right place to lodge your petition is the Court of Appeal. Like I said, I'll repeat myself. If anyone contests for the post of a governor or for the seat of the presidency, the person is not satisfied with the outcome of the election, the person has the right to petition but to Court of Appeal. Then every other candidate who have contested for any position outside these two can now go to the different other tribunals, which are the tribunals of first instance. Then when they are not satisfied, they can now go to the proper court as an appeal. Then from there reaches. Then for the gubernatorial and presidency, the first court of first instance is the Court of Appeal, after which the Supreme Court, like we all know. So now I'm going to, before I even started this thing, okay, I was supposed to tell you the grounds upon which any candidate can come up and say, I'm not satisfied with this election. There are like 4 as enshrined in our Electoral Act. One, if the person who's been said to win the election did not win, is not ought not to be the winner with regards to the amount of lawful votes cast. The person who is aggrieved can say, okay, I'm not fine with this. And again, in an election, an appeal from, sorry. So, sorry, let me check my book. So I think I made a mistake. Then that election was invalid by reason of corruption practices and non-compliance with the act. And also, I would also like to state that if an election is conducted and for whatever reason some actions are not in compliance with the Electoral Act, the election cannot just like that be said to be, that cannot really be a reason for someone to say, I'm not satisfied, except if the omissions or acts that the person is aggrieved about has substantially affected the result of the election. So if it does not substantially affect, there's something we call partial effects and substantial effects. So if it partially affects the election result, well, you don't have any reason to, you can't on that premise say you are not fine with the election, you want to contest, you want to write a petition or whatever, you're not fine with it. But if it substantially affects it, well, you can go all the way, you can petition and all that. Then another reason is that the petitioner or its candidate who was validly nominated but was unlawfully excluded from the election. So this part now reminds me of the case of Amechi versus INEC and 2 others, which the case started in 2007 and judgment was given by the Supreme Court on January 8, 2008. So in this, I'm not going to go into the whole details, but this part the case generally is just about someone who won the primaries, and his name was submitted to INEC, being the person to run for the main election, gubernatorial election, and however the political party went ahead to put in another person to contest for the position. Then the person they put finally won the election, but the aggrieved party, who was the person initially that won the primaries, that his name was submitted to INEC initially, went to the court, approached the court, and after everything, the swearing in that was meant for the person who eventually contested and won the election was now transferred to him who was aggrieved. So, but however, in an election, if the person who has the most amount of lawful votes cast, for whatever reason, is not, it has been unjustly elected, INEC, the law says that the person who has got the second to highest number of lawful votes cast cannot necessarily be now sworn in as the governor. Instead, INEC is going to conduct like a rerun, what we call a rerun. So, and I'm going to also state, okay, I'm not done with the the grounds upon which someone can say, I'm aggrieved, I want to petition. So I think the last one that I have not made mention of is that the respondent was not duly elected by the majority of lawful votes cast, of which I have also made mention of it while I was talking on the other ones. Then I think I've also mentioned that the election was invalid by reason of, okay, that the person whose election is questioned was at the time of the election not qualified to contest for the election. So we already know that there are grounds, not so many, but there are grounds upon which someone can be said you're not qualified. For instance, if you have been convicted, you cannot contest for anything. So supposing someone has been convicted for a crime in the past, and the person went ahead to contest in an election, and the person won. So that person now, the person's situation can fall under this one. Then I wanted to make mention of something which I forgot. In the past, I said that the petitioner or its candidate was validly nominated but was unlawfully excluded from the election. Then the part that says the petitioner or its candidate, meaning that here now, I know it may confuse some people. The petitioner here can be, stands for like the political party, because in an election, there are only two people who can contest an election. There are only two people in an election who can say, I'm not satisfied, I want to go to court. And the two people are, one, the candidate who contested, and secondly, the political party from which the candidate emerged from. So before all this, we already know that for the sake of this election, post-election issues, we know there are different stages of election, pre, during an election, and post. So this particular topic of today falls under post-election matters, post-electoral matters. So for the sake of this petition and tribunal issues, that's the reason the Act has said that 14 days before every election, tribunals ought to be constituted. So, in election, time is of the essence. That's the reason if you go through the Electoral Act, you see that almost everything has a day for it, has a time limit. So, like this one now, they said 14 days before every election, all tribunals ought to be set and with their right constitutions and everything. Like constitution, I mean, is like I said, the number and caliber of persons who ought to be there for the sake of giving judgments and hearing the matter. So 7 days before the election, all the registries in these tribunals ought to be open and ready, so that once the election, things that, and already, for someone to bring a petition, so someone to say, I'm aggrieved, I want to go to a tribunal or a court, depending, the person ought to file the case within 21 days after the declaration of election results. If it passes 21 days, you're out of time, and well, depending, yeah, but the Act has said that you ought to file your processes or whatever for your grievances within 21 days after the declaration of the election results, and after 180 days, within 180 days after filing of the your processes and all that, the court or tribunal ought to have heard and given judgment. Then, within 90 days after the judgment, the judgment, if there's any appeal that has arisen from that, from the judgment of the court or tribunal, the court of first instance or the tribunal of first instance, of course, the judgment ought to be heard and disposed of within 90 days. Like, okay, maybe I haven't put it correctly for you to really understand me. First of all, I said, if a candidate is aggrieved and the person wants to go to court, the person ought to file his processes or her processes within 21 days after the declaration of election results. Then, within 180 days after filing, the matter should have been heard and judgment given. Then, within 90 days after giving the judgment in the court or tribunal, the appeal ought to be heard and disposed of. That's within 90 days after the judgment from the court of first or tribunal of course first instance. Then, After you have given and now the court, like I said, for gubernatorial, the first court of first instance is the court of appeal. So after which you can go to the Supreme Court if you're still not satisfied. So that the Supreme Court now has the right to give its judgment and give the reasons later, because in an election, it is pertinent that the Supreme Court, the final court, or the final court for hearing of whichever of any electoral matter, has the right, has the duty to give reasons for which it has given the judgment, for which it has given any judgment. So now they are at liberty to give their judgment and now give you reasons, like schedule another date for which they would give their reasons. Um, so right now, I would also want to take us through I would also want to take us through the fact that in all the electoral stages, that is the election, the pre-election, during election, and post-election, you can't, most times we can't really differentiate the parts, which state, the phases. Like most times you can't really say, okay, from this to this is the pre, and from this to this is the during election or the electoral stage, and from this to this is the post. Because sometimes some things that have happened, in the well, something can be happening, could have still happening from the pre-election to the during election stage. So sometimes it's difficult for people to really understand. But one thing for sure is that for post-election stage, the petition and going to court and all that is at the post-electoral stage. And for any party, any person who wants to contest, okay, there are so many reasons. Okay, someone can come up and say, someone may come up and say, without a very good advice from a lawyer or without good knowledge, if someone can come up and say, I am not fine with this result. I'm not fine with this result. Maybe because you ask the person can tell you, yes, on the election day, the collation officer, the APO1 was supposed to do this, and the person did not now do this. When the person was asked to do this by the INEC official, the person did not now. Those are flimsy reasons. Okay, if someone does something that is contrary, to the instructions of the commission here now is the INEC or the electoral officer, and the thing is though out of what the provisions of the act, but does not substantially affect the election results, that cannot also constitute a reason for which someone should say, I'm not fine with this and I want to approach the court. So there are so many things people, so many premises on which people base their dissatisfaction. But if you go through the Electoral Act, you see that sometimes these things, when they even eventually go to court, on first hearing they are knocked off. So that's the reason when you actually get to see matters that have actually gone through the matters that are well known, electoral matters that are well known, you'd see that the reasons for which the dissatisfied candidates brought the matters are very substantial. Like the person was not qualified in the first place to contest an election, or the person was not the person who had the most amount of votes cast, which is very substantial, or for whatever reason. So I would also like us to know that for someone to actually have contested in an election, the person should have gone through the different stages of election. Like I said, there are 3 stages: the pre, the during election, and the post-election. So this is all we have for today with regards to post-election matters. And I hope you all join us next time as we bring in another interesting topic. Bye.